How do I, as an experienced attorney, decide what witnesses to call and what questions to ask them? Recently, I've had a lot of commenters who sound like they go to Law and Order, SV University, so I thought it's easy enough to explain. Let me just get everyone on the same page. Special thanks to all of you who have subscribed or watched my recent videos. I really appreciate it. This is a new hobby I'm trying and I enjoy doing it. But based on the questions I've received in the comments, there's a lot of confusion on when to call a witness. There's a lot of second guessing Tory's attorneys about one, why wasn't Meg's bodyguard called? Why wasn't Quan called, Corey's driver? Wasn't he there? Why weren't the doctors called? Who was this witness subpoenaed but not called? What about this other witness? Also, why did the attorneys ask certain questions and not ask other questions? These are all fun questions to ask ourselves after the fact, Monday morning quarterbacking. But what I want to explain now is the process an experienced attorney would go through on how to call a witness. It sounds basic, but there's a simple mathematical equation I use that I was trained in. And as an attorney with my experience, I'm happy to share. If you want more videos like this one, go ahead and let me know. Otherwise, I can go back to doing celebrity gossip videos, whatever works for you. Hopefully, this will help you learn how to discuss law intelligently on the internet when it's time. The first thing you do, step one. The first thing you do is decide which facts you need to win the case. You can't win a case without facts, and the facts all line up to make a story that supports your argument. You're not allowed to just make things up. You always need to master the facts to properly represent someone. So, number one, what I do is decide what all the facts are that I need, that are necessary for your case, and I physically list them out. You could do it on a computer. I like to do it longhand. I've done it on like the boards that look like you see in the back of a police station on TV. But usually I'll just put butcher paper like at Romano's Grill, take a big pen and write out all the facts I know are coming in, all the facts I want to come in. And I even put the bad facts, the ones I know the prosecutor, in my particular case, is going to use to bring it on the case. And on the same chart at this stage, usually I want to get them out of my mind. So I put them all down in a list. Step two, I make a list of people and tangible evidence. By tangible evidence, I mean evidence you can touch. So photos, phone records, if there's an audio tape, whatever I need, whatever I might want to come in or what I don't want to come in. And I make a list. It's got to be all the witnesses and all the evidence, an exhaustive list. So now I have a list of people. Now I have a list of facts of what I need. And then I have a list of people who may or may not be able to testify to those facts. Step three, I start drawing lines and connecting witnesses with the facts they know. For example, one witness may be able to testify to multiple facts. Some facts may have multiple witnesses. That's the point. What we're doing now is we're building the spider web. I don't put maybes or I think they know that. I think that might have been what happened in this case with Sean Kelly. But if you have a maybe this witness saw a certain thing, now's a good time to call the witness and double down. Now you double check and make sure you can figure out, one, if the witness knows those things. Two, if the witness is willing to cooperate with you and even discuss with you about the facts they have. That's also something that's important to know. But at this point, I now have a list of all the people who can testify, what they could potentially testify to, and I know who relates with what. So, you can start to see which witnesses are the most important. For example, any witness who either one, saw a lot of different things, there's a lot of lines coming to different facts, or two, any witness who is the only witness to a particular event. These are the most important witnesses. So those are the witnesses I start with for the next step. Hang on. What if there's a fact on your paper that either doesn't have a witness or the witness, you don't have a witness who can testify to that particular fact? This is the point where you need to go back and either one, find a witness. You got to go get an investigator or do your own investigating. You do your footwork to find the witness. Or two, you got to change your theory of the case. If you can't find the fact if you can't find a witness to support the fact you need, then that fact isn't there in your case. You cannot argue defense that is not based in fact, that is based clearly on speculation or imagination. So go back and find the witness or change the fact to be something that you can introduce. Okay. Step 4. Now, we have our list of witnesses. We have the list of facts that we need to get for them in order to testify. But before we decide what witnesses are we are going to call, we got to figure out the downsides of each witness. So, for each witness, this isn't its own column, it goes under each witness. We list out two things. There's two types of downside. One is believability. The second is the bad facts they will testify to. Remember, we don't list this with the good facts. This is per witness. I'll tell you why in a minute. Believability, for example, prior gang record, gang affiliation, drug record, criminal record, gang affiliation, some sort of relationship with the defendant or other witness. It doesn't have to be romantic, it can be any type of relationship. And it doesn't have to be so concrete. It could just be the witness is not well spoken. Maybe they can't get the words out correctly. Maybe the witness is too quick to answer and they say the wrong thing even if they don't mean it. Maybe the witness just doesn't like me and they don't really want to testify. I don't like calling witnesses who don't want to testify as a defense attorney. Sometimes you have to, but you'll find that a witness can be very vindictive if they choose to be. So if you put someone who's there who doesn't want to be there, it's always a last-ditch effort. You really want to avoid that as much as possible. There's also the physical impossibility that you can put down in this section. Was the witness view blocked? Their attention was distracted? Any of those type of things. Now, those things bled into the second type, which is the bad facts. So, for example, Sean Kelly was supposed to testify that Kelsey fired the gun. Great fact for the defense. If Kelsey's the only one who fired, wonderful. But he's not related to either party. He's a mild-mannered neighbor. There's no obvious bias. That's all great. He has an accent, but it didn't seem to affect his testimony. But if defense calls him, he's now also going to say that Tory fired a gun. He's going to say it's in the air, supposedly. But that's what he's going to say. So if you call him to avoid the assault, you automatically lose the possession charge. And once he says Tory fired, there's a chance that you're going to lose the negligent discharge too, most likely. What about Quan, the witness Quan? This is Tory's driver who was in the car, purportedly saw the whole thing. Now, he has a prior relationship with Tory, so that may not be good for the defense. It's not fatal. I mean, people have relationships with who they're around, so it's very natural you have a relationship with the witnesses. We also don't know what the other facts he may testify to are. Let's assume the attorney who prepared to defend Tory talked to Quan. If those facts were going to be good, they would know the vision could be blocked. His view of the fight or the girls or Tory could be blocked. Or the other alternative is what he was going to testify to, honestly and truthfully on the stand, would have been bad for the defense. That's a very real possibility. So as a juror, you're not allowed to predict if what he testified to would or would not have been bad for the defense. You can't consider that. But as an attorney, you need to know. And if you think it's going to be bad, you do not call that witness. Now, if you've made this chart, the defense would know that the police officer is pending some domestic violence case. The prosecutor would know Kelsey is married into Meg's old label and there's some legal issues there. There's some tension there. These are important things to chart out. Why? The way I was taught is that if a witness cuts both ways, if some of it's good for you but also bad for you on the defense, you just don't call them. Now, sometimes you can't get around it. I get that. But keep in mind, better you lose the marginally good fact than you risk calling the witness that puts the gun in your client's hand. Okay, that was the final step. So what did you just make? And why is this important? Why did you build this out? Whatever you just made, here's what you have. You have a list of all the facts you're going to bring out in your opening statement. You know specifically what to tell the jury as far as giving them a roadmap of the trial. Over the course of this trial, you will hear from X witness. This witness will tell you A, B, and C. You know who your best witnesses are, and you can prepare those witnesses and the jury that they'll be giving you the truth. You also know every single witness you're calling in the trial. So while you don't know the exact questions that you're going to ask, you can always work on those. Or to me, it's more natural at this point to just have it as a conversation. You know the general topics. So you're going to hit for each witness. Whatever the fact is that line connected to. This witness saw blood coming from the foot. So when you arrived at this time, what did you see? Tell me more about that. You can get your facts, get them clearly, and move on. Juries like clear and concise. They respect the preparation and they expect respect the clarity of the questions and the storytelling. Now, this is what's also important. You also have a list of the bad facts you need to prepare the witness to rebut. Uh, if your witness cooperates with you when you prepare them to testify, you know precisely what to ask first. You expose, before the other side can ask it, you expose the weakness to take the punchline away from your opponent. Now, you slept with the defendant, correct? You lied about that on national TV. Why would you not want to announce on national TV a list of people you slept with? You guys have seen 8 Mile. It's the B Rabbit technique. You argue everything they can say bad about you first, but you have that list, and then it takes the punch away from them. They have nothing left. You also know exactly what pieces of tangible evidence you need, and you know which witness you could use to lay the foundation to get those pieces of tangible evidence in. You know who the foundation is for your phone calls, for your photos, and it's all easily outlined, and you've done the outline already. So as soon as you get to that witness, boom, you know which ones you're calling and which one you're asking those foundational questions about. The other thing this preparation does is it tells you who your backup witnesses are. You made this list, so if your witness forgets, mumbles, or misspeaks a fact, doesn't show up until the last day of trial when it's too late to call them, you know who you can call as a backup witness to testify to any of the important facts you put on your list. If you need to, you don't have to scramble. Not only do you know who you can call, but you also have an outline of what to ask and what to be careful of once you call that person. Finally, if the other side calls any of those witnesses, you already have your prep out with all the cross-examination points. 1, all the good things they saw that help you, and 2, all the reasons not to believe that witness that you could bring out, hit them with, and then argue to the jury in closing. So that's how I prepare, as well as the attorneys I've worked with for relatively linear cases like this. This is a very linear case. Everything goes in order. There's a couple more complicated steps: how we make a file, how we footnote the location of prior statements for impeachment or refreshing a witness. But I think we can do that another time. I think this is a good start. So hopefully that prepares you to argue intelligently on the internet. Good luck. Please follow if you have any other questions or any other topic you're interested in. Foundation, hearsay, objections, let me know. I'll do what I can to make it more interesting. Thank you guys again very much.